He didn't kill me, but my life left. You know, like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden.
Because if the gun was not jammed, I know for sure he would have came after me. I mean, for the whole night, I didn't even know she was alive or dead because they didn't give any information.
We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Michael Winquist in person in custody with counsel Eugene Harrington. We're set today in this matter for the sentencing portion of this case. Mr. Winquist pled guilty on September 8th, 2025 to count to count one amended to second reckless injury with a firearm as a domestic enhancer, count 2, 3, 6, 7, and 8. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. All right, before we move to arguments from the attorneys, I'm going to have the victim impact statements. And for the record, please state your relation to this case.
My relationship to Christina is her mother.
All right, you may begin.
Well, I mean, really, what can I say? I mean, Christina has been shot. She's had to go to the doctor several times during the month. I think it was, don't quote me on this, but I think it was like 34 times out of 30 days that she was at the doctor. It's caused a huge hardship within our family. I mean, really, what can you say? My daughter's been shot. Yeah, she may look normal, but she's not normal inside. Her cognitive ability is not there. And then you expect her to live a life, and the rest of us to live that life as well. I mean, it is what it is. I mean, the doctor's reports and everything has been there, has showed everything. She's not okay. And, you know, let's get back to where, you know, the very beginning of really what happened and what's gone on. And that's what I expect the council to do. Thank you.
Thank you.
What the court has just heard is not argument. It's consequence. Under sentencing law, victim impact statements aren't about influencing guilt. They exist to give the court a full picture of harm. And here, that harm is permanent. This mother isn't asking for sympathy. She's documenting loss of function, of independence, of the life her daughter once had. Legally, this testimony directly informs the seriousness factor. Emotionally, it underscores what the statute already recognizes, that some injuries don't end at the hospital. They follow families into every day that comes after.
And you are the victim's son?
Yes.
All right. What would you like me to know?
So, like, I don't really understand why it's not child endangerment is added to it. Because if the gun was not jammed, I know for sure he would have came after me because I was still in the house. I was behind, like, one of these walls right here. I was behind one of those.
And you're pointing to the jury box?
Well, like...
So it was that high?
No. So our stairs are on the other side, and he was over here in our house by the fridge. He could have easily, because there's no basement door to get out, so he could have easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. I mean, for the whole night, I didn't even know she was alive or dead because they didn't give any information. And then I had to stay away from my mom 3 months. 3 months. She had to heal, and I was living at my aunt at the time. We saw her for the first couple of days, saw her breathing tube down her mouth. She could not talk for the rest of the week after she got shot. And then the next week, she was a little bit better, and then we saw her heal. But then she said, "I can't hear you, Donovan. You need to speak up." And then they're thinking about that she won't even remember me ever again. But that was proven that she could remember me. It was just a hard time. We're struggling to pay bills, all because of this happened. And then we get robbed like a couple nights after. And then, I don't know. And then we expect him to come back to the same community, live his life, a normal life. He can do whatever he wants as soon as he gets out. But me and my mom struggle to do stuff that we want to do because it depends how her legs feel, depends how she feels that day. And sometimes she gets so scared at night that she comes in my room, makes sure I'm still there, and checks on me. That's how bad it is. That's how bad her PTSD is. I'm seeing weekly therapy with my PTSD because whenever she has a man over, I have to tense up or I have to get involved. It's just we can't live our life normal again. We can't trust any man that's in our house because we don't know what they're gonna do. And yeah.
Thank you, Donovan.
From a legal perspective, this testimony does something critical. It reframes the offense from a single act of violence into a continuing trauma, especially for a child who was present and believed his life was in danger. Fear like this isn't incidental. It's legally relevant. Courts consider the psychological impact on secondary victims, particularly minors, when assessing seriousness and community protection. This isn't just about what the defendant did. It's about who now has to live with the consequences. And the court cannot ignore that level of terror embedded into a child's daily life.
All right, and you can either state your name for the record or you can just use your initials.
Christina Fickbaum.
You may start whenever.
I struggle with it just for the simple fact that, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, one of the big things that, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that. Like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. I always tell people it's like in reference of when you blow out candles on birthday cake, that's how fast my life was gone. He didn't kill me, but my life left. And, the other thing too that's pretty hard is that he could have very well taken another parent from my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess, Debbie? Can you?
Is that all you would like to say today?
She's gonna have Debbie finish for her. Right.
Okay, and that's totally appropriate and fine.
The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There is one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen, I wasn't chosen, I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. You broke things in me you had no right to touch. I kept trying to heal with the same hands that hurt me. You didn't walk beside me, you dragged me. You weren't building a future, I was surviving a sentence. You were a storm pretending to be a shelter. You called it passion, but it was punishment. I watered dead things. I stitched red flags into rose bouquets. You weren't a lesson. You were a warning, and I just refused to listen. So tell me this, was that love or was it self-destruction wrapped in longing? Don't lie to yourself. And the worst part, I loved you deeply, but not anymore, not anymore. That's it. Thank you.
Thank you.
Victim statements like this carry exceptional weight because they address something the law cannot quantify: loss of identity. The court isn't just hearing about injuries, it's hearing about autonomy, memory, safety, and dignity being stripped away. When a victim says, "Well, my life left me," that speaks directly to irreparable harm, a key consideration when determining proportional punishment. Legally, this is no longer about a single act. It's about a sentence that must account for a lifetime of consequences.
Okay, I'm now going to turn to the attorneys for arguments. Mr. Schmidt.
As the court recalls, the state is free to argue in the sentence, except that the second-degree reckless with the dangerous weapon will be concurrent to the felon in possession of firearm associated with the firearm used in it. And that will be consecutive to the felon in possession of firearm charges associated with the guns in the closet, which will be concurrent with each other. That means the state is therefore capped at 12.5 years initial confinement and 5 years extended supervision on the first cluster, and 5 years initial confinement, 5 years extended supervision on the second. Totals about a 27.5-year sentence of imprisonment, which is comparable to what DOC recommended, which was a range of between 11.5 in and 18.5 in, aggregating all their consecutive counts, and 6 to 7 out, aggregating all their ESs that they recommended. The state's recommendation.
I think that's incorrect. That's not how I added up what the DOC's recommendation was. I believe for count one, it was 5.5 to 6.5 in. And then 2 to 3 for all other counts, consecutive, all consecutive.
Yes, I added them up, and that's what I added up to if you run them all consecutive. Unless if I read that wrong.
They're all consecutive, okay, consisting of, oh, they did 1 to 2 initial, that's right, okay.
But
I wrote down 2 to 3 and it's 1 to 2.
yeah, my recommendation is going to be the upper end of what I'm capped at. It's going to be 17.5 in and 10 out, which is relatively close to what DOC recommended. In Wisconsin, for any case, for any sentence, the court must always consider probation first. It must consider something called the McCleary-Gallion factors, which is the gravity of the offense, the character of the offender, and the need to protect the public. When we actually argue this in practice, we usually break down those more abstract legal terms, those three, into more specific things like deterrence, punishment, incapacitation, rehabilitation. Those subcategories of those factors are easier to break apart and discuss and apply facts to than something general and big like protection of the public. Those factors and sub-factors, I believe, can be generally split into 2 categories. Factors are supposed to be predictive of behavior, related to the character of the offender and the need to protect the public. Those are things like specific deterrence, rehabilitation, incapacitation. Those are all things that the judge has to largely look at the facts and predict what's going to happen in the future. What is the lowest sentence that will specifically deter this offender from doing this again? What is the sentence that will rehabilitate this offender in the future so it won't happen again? If it's not possible to fashion a sentence that could accomplish those things, do we simply incapacitate the offender with a long sentence? That's what I mean by predictive factors. The other factors have to do with largely what we might call accountability or more broadly public policy. These are punishment, general deterrence, and not depreciating the seriousness of the offense. These are factors that have less to do with the defendant as an individual and more to do with the nature of the offense and its relation to the community. The public needs to know how different behaviors will be generally deterred from other people who would do them in the future. They need to know that offenses involving particularly bad morals or bad mens rea or bad impact to the victim will have that cause higher social and victim costs will have higher penalties to satisfy the general social and psychological need for punishment, and to not depreciate the seriousness of the offense by doing something that would offend and depreciate. In both those regards, this case is largely fact specific. So I'm going to quickly overview the facts of this case as it relates to that. This is a case where Michael Winquist shot Christina Fickbaum in the head with a shotgun, not outside, not during like a hunting incident or cleaning a weapon, but for no reason at all. It was done in the kitchen, and there was no danger there. There was no home invader. There was nothing like that. In the days leading up to the offense, there were no indications that this was something that was predictable that was going to happen. Analysis of the phones of both of them showed the relationship was good. According to the child who was there in the home, there was no argument in the immediate lead up to it. There was an argument earlier in the day in which they were arguing about money related to the child's father owing them money and a need to possibly engage in civil suit for that. What happened is at some point in the day, Michael Winquist, who had not been sleeping for days, had been drinking constantly for days, was on what you might call a bender, suddenly was heard by the child who was in the basement, suddenly wake up, crashing around the bedroom, stumble to the kitchen. He heard a gunshot. His first thought was, well, Michael Winquist often will like shoot like squirrels and varmint and things like that, until he heard a body drop. And then he went up and found the image of Michael Winquist in front of his mom with a gun with her bloody on the floor. He fled, and when he was outside, he had to watch Michael Winquist shoot himself. He wasn't sure if Winquist was dead or not. Later on, he would go back in and remove the firearm. Michael Winquist was there ineffectually doing some sort of care to the head wound while mumbling something about dreaming. The victim, Christina Fickbaum, miraculously survived. She survived a gunshot wound to the head. In fact, she walked herself out of the building to EMS outside. The injury that she really was inflicted with wouldn't become apparent until later. In fact, if you watched her right after the incident in the hospital, you wouldn't detect any sort of impairment in how she's interacting at all. None of the cognitive or neurological issues that you've heard from the victim statements today. That was an injury that has worsened and festered and grown and gets worse with time after the injury was inflicted, the initial gunshot. Michael Winquist at the time was on probation. He was on probation for felony OWI. He is prohibited by the conditions of probation from consuming, possessing alcohol. Absolute sobriety. He was prohibited by the law, because of the felony nature of the conviction, from possessing firearms. The firearms in the closet should be concurrent to each other because they're mostly Miss Fickbaum's weapons. They are stored in the same place. It's Miss Fickbaum's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those two things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17 and a half in, 10 out, with max on the reckless, max on the felon possession of firearm, those concurrent to each other. And then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
What the prosecution is asking for here isn't symbolic. It's structural. This recommendation is grounded in proportionality, matching the length of confinement to the permanence of the harm inflicted. The argument centers on a simple legal reality. The victim's injuries are lifelong. That fact reframes sentencing away from short-term punishment and toward incapacitation, deterrence, and public safety. The prosecutor isn't asking the court to speculate. He's asking the court to acknowledge what the record already proves, that no sentence can undo the damage, but a substantial one can recognize it and prevent it from happening again. At this stage, the law demands accountability measured in years, not sympathy measured in words.
Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know.
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. I would also like to apologize to Donovan. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that have had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
Is that all?
Yes, Your Honor.
A defendant's statement at sentencing serves a narrow legal purpose. It's not about persuasion, it's about insight. The court listens for accountability, consistency with the record, and whether remorse is tied to understanding harm rather than fear of punishment. Here, the statement is noted, but it does not resolve the unanswered questions the court must confront. Words alone do not offset prior conduct, nor do they negate the seriousness of the offense. At sentencing, remorse is considered, but it is weighed against facts, history, and risk, not emotion. From a legal standpoint, this moment doesn't close the case. It frames what the judge must decide next.
Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense and not wanting to unduly depreciate that gravity, and to find a term of incarceration to meet the court's objectives, the court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident. With regards to count 1, the second-degree reckless injury with the domestic abuse enhancer and the modifier of use of a dangerous weapon, the court is going to sentence you to 17.5 years of initial confinement. That would be the 12.5 years for the underlying second-degree reckless injury, plus the max for the use of a dangerous weapon modifier of 5 years. The court finds this to be so egregious, so serious, that the maximum possible penalty is necessary, not only to protect Ms. Fickbaum, but to protect the public in general, because I have not seen that you have a desire to follow the rules and to follow the law in any way, shape, or form.
Judge, I'm interrupting. I do that at risk. You said 17.5 years confinement. I think the maximum is 17.5 years imprisonment, 12.5 confinement, 5 and
12.5 confinement. Okay, I read that on Mr. Schmidt's argument. So 12.5 years. Well, Mr. Schmidt, because it says the maximum, not more than 12.5 years. Oh, 7.5 is the maximum. Sorry. I apologize for that. So with count 1, the court is going to sentence you for the underlying second-degree reckless injury, 7.5 years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12.5 years of initial confinement with 5 years of extended supervision. as it relates to count 2, possession of a firearm, convicted felon. The court also finds this egregious, the fact that he knew he was a convicted felon. As applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other. As to count 3, possession of a firearm by a convicted felon, the court finds that that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2. As to count 6, possession of a firearm by a convicted felon, the court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2 and concurrent with count 3. For count 7, possession of a firearm by a convicted felon, the court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2. Count 8, possession of a firearm by a convicted felon, same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2. In my calculation, it's 26.5 years of initial confinement, and I believe 16 years of extended supervision. On extended supervision, when he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program, until the last 3 years of his sentence, if any. On extended supervision, absolutely no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription, gainful or some type of employment to occupy his time and his mind. It does not have to be full-time. It can work with his disabilities. Absolutely no contact with Christina Fickbaum or any of her family members, any residents, any employment that she may have or her family members may have. The court is also going to order that he has an AODA assessment and follow-through treatment. He engages in some type of criminal thinking, such as thinking for a change or breaking barriers. The court is ordering $12,582.23 in restitution. The court is going to order $518 in court costs and fees per count, except for count 1 has an additional $100 due to the domestic abuse surcharge. These are felonies. Absolutely no use or possession of firearms for life. No voting in any election until your civil rights are restored. Court is ordering his DNA. This is not something he can have expunged due to the seriousness of the crime. Failing to pay his fines and fees, a civil judgment will be entered. If he is released on extended supervision and has not paid his fines and fees, a warrant will be issued. He can sit up to an additional 6 months in jail. The court ordered court costs, surcharges, and fines are to be collected as a percentage as determined by the Department of Corrections to be reasonable while he is in a state prison. And as a condition of extended supervision, he is ordered to pay those upon release. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. All right, then we are adjourned.
What the judge delivers here is not a single punishment. It's a structured judgment. Each count reflects a separate legal failure, and together, They form a sentence built on gravity, risk, and consequence. The court weighs permanent injury, use of a firearm, prior prohibitions, and the cascading harm to victims who will never return to who they were. This is why the sentence isn't symbolic. It's cumulative, intentional, and designed to incapacitate, not out of anger, but necessity. At its core, this case illustrates a hard legal truth. Choices don't just violate statutes, they rewrite lives. The law can't restore what was lost, but it can draw a line that protects others from the same outcome. In this courtroom, accountability isn't emotional, it's measured. And once measured, it becomes final.